a piece of legislation that was structured on the principle of hear no evil, see no evil, speak no evil, designed to find out nothing, investigate nothing, report nothing that could cast any doubt on it being anything other than an unblemished success.
Welcome to Assisted. I'm Chelsea Roff. Assisted dying is said to be a compassionate, caring choice.
In this series, we explore why it's not that simple. I'm Fiona Mackenzie, and we'll look at why assisted dying has such a big impact on women. I'm genuinely very, very pleased tonight that Robert Clark, who is over in Australia, has spent some time with us to tell us what he saw and what he sees in Victorian assisted dying. Robert is a former MP and a former Attorney General in the Victorian Parliament. He's also past President of the Liberal Party and was in Parliament when the Victorian assisted dying regime was rolled out. Robert, thank you so much for joining us in your evening.
Good to be with you.
You were in Parliament at the time this was introduced. What did you see and how did you get involved in the debate then?
Well, it came about because the Premier of the day, I think, took it on board as a project he wanted to see through for whatever reasons, and he sort of just gradually built up the pressure, sort of set up a process, corralled various of the MPs of his own party, etc. Then the legislation was pushed through. It was, to be honest, it was a completely disgraceful process in terms of the lead up to it. There was a parliamentary committee of inquiry that read more like a euthanasia advocacy document than a dispassionate inquiry. Then the bill was sort of pushed through with several all-night sittings, one in our lower house, at least one in our upper house, to the point where MPs were exhausted. It was really a piece of legislation that was structured on the principle of hear no evil, see no evil, speak no evil, designed to find out nothing, investigate nothing, report nothing that could cast any doubt on it being anything other than an unblemished success. So it's quite a disgraceful process. And what particularly made my blood boil was that all this was being done at a time when there was huge gaps in palliative care in Victoria. So people were being offered assisted dying, assisted suicide, but the government was doing very little to offer them better palliative care. And of course, the result is people could be dying in pain and opting for assisted dying simply because they couldn't get the palliative care that they wanted.
There are so many parallels with what we see here.
Absolutely. And you'll find that UK is anything like Australia, that the palliative care situation certainly hasn't improved after assisted suicide was legalised in New South Wales. There were claims that palliative care had been sorted as part of the deal to get the legislation through, but then subsequently budgets were cut, and the Australian Medical Association and Palliative Care Victoria are highlighting the fact there are huge gaps still in palliative care, unacceptable waiting lists, particularly in the western suburbs of Sydney, which are the more working class battler suburbs. With all of these regimes, it's sort of all very well in a sense for people who are well informed and know their way around the system. It's the people who are the battlers, the people who believe that doctor knows best, the people who are struggling to get the medical treatment, palliative care that they need. Those are the ones who are really going to suffer at the end of this, let alone, as you've already highlighted, people who are subject to family violence, elder abuse, or other distressing situations in the home environment.
I'm so glad we're talking about this, because there was a very broad range of witnesses invited from Australia to give evidence to MPs here in the UK. So there was an MP from New South Wales, doctors who've been involved in the rollout, practitioners as they call themselves, so those who are involved in actually delivering assisted suicide or euthanasia. But of those five witnesses from Australia, they were very clear that although there had been some issues in implementation of assisted dying, actually things had all been in the hands of professionals. You know, they'd all been kind of ironed out and it was all going pretty well. Do you think MPs who are turning onto this discussion in the UK would be right to be reassured by what they heard from those Australian witnesses about assisted dying with you?
No, absolutely not. The witnesses were all, I might say, sort of handpicked to be those who were prominent supporters of assisted suicide. The MP who from New South Wales, I think, was one of the key proponents of pushing it through the Parliament, to every one of the medical practitioners involved in assisted suicide themselves, a founding member of the Australian New Zealand Society for Voluntary Assisted Dying, on the review board in Victoria. They all had very strong barrows to push. And conversely, I know from the transcript of the evidence that a number of very prominent doctors who were opposed to assisted suicide were suggested to be called as witnesses. and none of them were. So it's a very one-sided presentation to the committee. String after item after item of claims that were made by those witnesses just don't stand up to the facts.
Australian witnesses, I gave evidence in Parliament, and they followed the day I gave evidence, and I'd given evidence on the risk to people with eating disorders. It was really remarkable to then see the following day multiple witnesses from Australia each really make a point of saying, nope, would never happen here. Anorexia would never fit through the door in Australia under this law. And I want to go back to what you said about hear no evil, see no evil, speak no evil. One of the questions I've had is the structure, the reporting structure in Australia good enough to really be certain of whether the safeguards are working as intended?
Absolutely not. As I indicated before, the whole system seems designed to exclude the possibility of any such evidence ever becoming public. In Victoria, they report a bland range of numbers of cases, how they progress through the various stages, bit of demographic data, bit of data on practitioner involvement numbers. They've got some data on palliative care receipt, but it really just, as far as I can tell, just indicates who's been on the books of a palliative care provider. It says nothing about the level of palliative care that's been received. The whole policy is don't look at anything behind the paperwork. The two doctors who are involved in assessing the patient to prepare the paperwork. It's lodged and reviewed by a public servant. The public servant ticks it off. The permit for the assisted dying substance is issued. There's no audits of what actually happens. There's no program of random case reviews. There's no obligations for adverse event reporting afterwards. There's no opportunity for anybody involved who might have concerns about it to flag those concerns, your family members or social workers or patients' regular GP. There's no process for any of them to have any input into it. And there was one notorious case which sort of highlights it, where an application was lodged. The public servant reviewing it noticed that although the witnesses had signed to certify that the patient had signed in front of them and knew what they were doing, the patient hadn't, in fact, signed the paperwork. So instead of throwing the whole thing out and starting an inquiry as to what went on there, they simply sent the paperwork back to the doctor, said, hey, the patient hasn't signed. The doctor got the patient to sign, resubmitted the paperwork, and it all went ahead. I mean, that's the sort of standard of review that we're getting out of this system in Victoria. And the so-called Voluntary Assisted Dying Review Board is itself made up of members who are personally committed to assisted suicide and have a strong interest in making sure that nothing comes to light that could cast any doubt on how well it's working. So without that independent review, with limited gathering of data, how on earth can you expect anybody to properly scrutinise what's going on in Victoria? And what that means is witnesses can come along to the UK parliamentary inquiry and give all of these assurances, and they've got nothing of substance to back them up.
There are so many parallels with what's being proposed here. It's important to also say that the bill that's proposed in the UK is based on the Australian model, so of course it would be similar. But as you say, there's no right for family to intervene if they are concerned. The board will have a death commission here, will mark its own homework in the sense that, you know, there's no kind of automatic referral to the police. Going back to when this was rolled out in the Parliament, I think you were quite heavily involved in, I suppose, trying to argue for stronger safeguards and better outcomes, and presumably to stop the law. Is that fair?
Well, absolutely. Primarily to stop the law, because I don't think that any safeguards or any independent oversight can prevent the fundamental systemic problems with assisted suicide, because even with the best attempted safeguards in the world, the fundamental effect is going to be to change attitudes within medical practice, to lead to many people inferring an implicit recommendation of assisted suicide by practitioners, and particularly those people who are less familiar with how things work, more inclined to believe that doctor knows best, taking that as a cue that that's what they ought to do. From the point of view of practitioners, the sort of the normalisation of assisted suicide, the view that it's just one medical option amongst many, means that doctors then feel they've got a professional obligation to put that before their patient, and then their patient takes that as well, maybe if the doctor thinks that's what I ought to do, that's what I ought to do. And that sort of swings attitudes away from caring and as the first attempt by what the doctor should want to do to alleviate the patient's suffering, to saying, well, okay, you're suffering, well, maybe you ought to think about assisted suicide. There's one particular aspect of the evidence that sort of highlights that, where one of the witnesses said, well, just because a patient asks for assisted suicide because they feel they're a burden on the family doesn't mean that it's not voluntary and therefore there's nothing wrong with it. I'd have thought the first attitude of a doctor traditionally would have been that if a patient comes to them and says, "Oh, I feel like ending it all because I'm such a burden on the family," the doctor's reaction would be, well, one, what can we do to ease the burden? Can we get you better home care? Can we get a visiting nurse? What can we do to make it easier and support you? And then the second thing is to say you shouldn't be feeling a burden on your family. I'm sure you've done a lot for your kids over your lifetime to date to look after them, and you shouldn't feel guilty about getting a bit back from them in return. So, in other words, trying to reassure the patient and help them instead of just saying, "Oh, well, it's your choice. Live. Do you want to live? Do you want to die? Well, up to you. Here are the two options." And of course, there's a risk that will get even worse than that. That the attitude will be within the medical profession. In your sort of situation, most patients would choose assisted suicide. You're perhaps being a bit stubborn and pig-headed in not doing it, and you're a bit out of line. Now, I think we're already seeing some of that in some of the attitudes uh, in hospitals about withdrawing treatment and levels of treatment and so on. And really, the ethos, it should be the patient's choice. If the patient wants to continue to receive treatment, then they ought to be able to. But there's an attitude, well, that there's a point when that just shouldn't happen, and I fear that it will move from a right to an expectation to almost a responsibility to accept assisted suicide. Now, that's not going to happen immediately. Changes in attitude will take place over many years as the existing medical professionals who've been trained with the traditional attitude of care and compassion and help for the patient slowly leave the system, and others come through who've been trained, well, it's a patient choice. You give them the options, they decide what they want to do, and you're just there to help give effect to their wishes. And then I think beyond that, I fear there could be that further change of attitudes that perhaps that's what you ought to be doing in your situation. So to come back to where we started, I don't think any safeguards can alter that attitude change.
One of the reassurances that we've heard in this country regarding Australia is when fears have been expressed that perhaps this law could be expanded in later years. So it's passed in one way and then Parliament comes back and, safeguards are slowly rolled back. Australia is held up as this gleaming model where the safeguards work exactly as intended. There's been no expansion of the law. And of course, it's often not mentioned that Victoria only passed its bill in 2017. So it's only been in operation for a few years. Has there been any change in the law since it's been passed? And are you seeing efforts to expand the law at all at the moment?
Well, the answer to the second question is yes. And indeed, it was ironic that some of the evidence, both to the Westminster inquiry and to the Scottish inquiry, was from Australian witnesses saying, no, it's slippery slope doesn't exist. We now know that behind the scenes, while all that evidence was being given, the Assisted Dying Review Board and others in Victoria were busy lobbying the government, lobbying those who were conducting the statutory review of the legislation for further changes. A few weeks ago, a report came out from that review, which had an appendix that said, well, our scope doesn't include whether we should change the legislation, but we just haven't received a whole lot of proposals for changing the legislation. Here they are in the appendix, so over to you, government, to consider them. And then the day that was released, the government came out and announced a whole bunch of amendments that it's now starting to consider making. And some of them are incredibly sweeping. The two worst ones are to move from an assisted suicide regime to a euthanasia regime. And probably doesn't need me to tell you what a difference that makes in terms of risks and everything else. And the second thing is to remove a restriction that has applied up to date in Victoria that says that practitioner can't initiate a discussion about assisted suicide. And that was something that was given quite a lot of emphasis in 2017. Don't you worry, it's not going to be pushed onto people. It's only going to be talked about if somebody wants to talk about it. And now the doctors are saying, this gets in the way of good medical practice. We should be able to initiate it just like any other treatment option. And that gets back to what I said before. If the doctor initiates the discussion, there are so many patients who are going to take that as a hint, an implicit recommendation from the doctor that that's what they ought to be doing. And the worst of it is that a lot of this initiation of discussion is going to be coming from practitioners who just aren't in a position to make a proper assessment about the patient's case and certainly won't know enough about the palliative care options. I don't know what it's like in the UK, but certainly in Victoria, a lot of general practitioners, indeed a lot of other specialists, don't really know what palliative care can do to help people. So they can think this situation's hopeless, this patient's going to die in a lot of pain, I ought to raise the subject of assisted suicide with them. Whereas if they had referred the patient for assessment by a palliative care expert, the palliative care expert would have been able to say, yes, we can manage your pain. We'll be there with you every step of the way. A lot of people take advantage of these final weeks to make their peace with the world and so forth and spend time with family, and we can ensure this happens for you. And that sort of compassionate attitude will be out of the window. And so patients will be making decisions to die based on unfounded fears that could have been laid to rest, except for the fact that a doctor who wasn't well able to know what they were talking about raised the subject of assisted suicide. And if that's allowed by others as well, and it depends whether it's extended just to medical practitioners or all health practitioners, you could have social workers, nurses, or others initiating a discussion out bad and putting the hint in the patient's mind, well, nurse or whoever it is, thinks maybe I've reached the time I ought to be ending it all, so perhaps that's what I ought to do. So it just gets back to what I was saying before. It will shift the whole practice of medicine away from care and compassion and what can we do to help relieve your distress to, well, if you think it's all too much, here's the way to exit. And I think that's just terrible.
And in the UK bill, in the Westminster bill, doctor initiation is allowed. So doctors are actually able to raise the issue with children. They're not able to start the process with children, but they'll be able to talk to children about it, including anorexic teenagers, as many have pointed out. That there is this sort of unbounded horror. But you were saying very clearly that Australia had limited scope when it was launched, but the organisation, the Quango, who is responsible for operating assisted dying, is now lobbying the government successfully, by the sounds of it, to get concrete proposals to wildly expand the law beyond the initial proposals.
Yeah, well, certainly individual members of it. One of them referred to that fact in the evidence they gave to the Westminster Committee. The VAD, the Assisted Suicide Lobby, has certainly been pushing hard for that. And if you look at the appendix to the government, to the official report to the government with that list, you can see a long list of things that removes safeguards and expand the system. And those who might have wanted to recommend changes that would have tightened it up or addressed problems didn't do so, because at the time the review was announced, it was said this review doesn't have authority to look at changes to the legislation. It just has to report on how the legislation's operating. But it looks as though quietly the word was given to those who, in the pro-euthanasia, pro-assisted suicide side of things, to get their submissions in, and they've been sort of smuggled in through the back door. So it's just, to be honest, just a continuation of the underhand way in which the whole thing's been handled in Victoria from the get-go. I suppose the other further point to make is this. Victoria was the original legislation, and every state subsequently has passed legislation that in some respect or other has removed safeguards or restrictions that applied in the Victorian legislation. So only Victoria and South Australia prohibit the initiation of discussion by doctors. I think West Australia and Queensland don't hold it to be, but I think it's those both allow euthanasia as well as assisted suicide. And now, of course, we've sort of gone around back to the state at the beginning, back to Victoria. Now Victoria, as it were, is trying to play catch up with all the other states to make the Victorian regime even more exposed to misuse than it was in the first place.
Why? I mean, well, I'll let Chelsea ask the next question, but we also have laws in the Isle of Man and in Scotland, and particularly in Scotland, who have a habit of wanting to show how much further they can go than the Westminster government. I would really fear that we'd end up in that situation where each has a different approach to safeguards, but because you can point to this happening in a different part of the UK, you can point to a good reason to justify, for rights reasons, for equitable access, that these safeguards are in fact barriers and should be removed.
Yes. Well, I mean, we're all convinced of the fact that the vulnerable, the ones who are most at risk out of this, it's all very well if you're well-informed professional, but it's sort of autonomy for the few and pain and suffering for the many is what's going to flow from this.
Yeah. I want to ask you a little bit about both the reporting, but also the accountability structure. So I've just pulled up the Victorian report on assisted death, the most recent one, which covers assisted deaths between June 2019 and June 2023. And it has a category in the they call it life limiting conditions instead of terminal conditions, but in the life limiting conditions report, and it's something that we see in the U.S. in the 11 jurisdictions in the U.S. where we've done our study. But it's this catch-all category, which is other. So you see cancer, and you see a breakdown of every single type of cancer and how many people sought assisted death for cancer, and then you see neurological, and then you see this category that just says other. And there's 112 people out of the 1,574 that were reported in this time period. So that's 5% of the deaths are just reported as a, quote, other condition. And it says it may include diabetes, HIV/AIDS, liver disease, kidney disease, and other rare conditions. So my question, given that, you've established that the reporting isn't so good, is there any accountability if a doctor were to misrepresent a condition as terminal? For instance, we've heard terminal anorexia. If a doctor were to say, well, I believe this person's anorexia is terminal, and they were to fall in this other category, is there any accountability? Can a patient's family, for instance, say, this doctor provided lethal medications to my daughter, and she didn't have what I believe was a terminal condition? Is there any accountability in the VAD law in Australia?
Look, in practice, no. In theory, I think a patient's family could lodge an allegation of a mispractice against the doctor who was involved, but it would have to be an absolutely standout case. And of course, once the patient is dead, where's the evidence to get a conviction beyond reasonable doubt, or indeed to get any professional action taken against the practitioner concerned? The doctor in the case we spoke about earlier, who submitted the paperwork without the patient's signature, was fined, I think, $10,000 or $12,000 by a civil tribunal, and then Death with Dignity or Go Gentle or one of the other lobby groups had a sort of crowd fundraiser to pay the fine for him. So it's sort of rap over the knuckles for non-compliance. Effectively, as I've said before, it's what's on the paperwork. The chances of anything behind the paperwork being exposed are close to non-existent. But just to give one completely outrageous example, in Victoria, the coroner's got no authority to investigate any death that occurs as a result of somebody taking the substance in the course of the legislation. So they can't investigate coercion or anything like that. They can't investigate certainly they can't investigate if the patient dies due to complications, with complications in the dying process due to the lethal substance not working properly. And we know from evidence out of the United States, particularly out of Oregon, that these substances often don't work the way they should. Indeed, even the Victorian board has reported that there have been instances where it's taken longer for patients to die than was expected. Now, they've disclosed nothing about whether the patient was unconscious. It just took them longer than expected to expire, or whether the patient was writhing around in agony. But whatever it is, the coroner can't investigate. And that's particularly appalling because in Victoria, we have overall a regime about the coroner having systemic investigations into causes of death to try to identify systemic factors that give rise to deaths and therefore make recommendations. But yet the coroner's totally shut out of the investigation here. I mean, look, we could go on and on about those.
No, but I think this is the point, Robert. So in the UK bill, as proposed Westminster bill, it removes the coroner's duty to investigate suicides in these cases. So in the UK, our government's just recognised that suicide of women who are in domestically abusive relationships is actually a huge issue, probably bigger than homicides. And the problem with this is that any suicide, which would be under this assisted suicide law, so any suicide of a terminally ill woman who is in a domestically abusive relationship, there'll be no coroner's inquest, no domestic homicide review, no multi-agency, just nothing. And obviously no right for family to get involved or to even know it was happening until after the fact. The coercion point is one I wanted to touch on, because I mean, do you see, I know the argument here is that coercion in people who commit suicide or who go to Dignitas in Switzerland is not detected until after the fact, and the police have to get involved. So this law is better because it pushes checks for coercion up front. So you have a doctor or two doctors reviewing that patient and detecting coercion. Do you know of any cases of coercion or domestic abuse that have ever been detected in Victoria? Or do you think it's likely that you would hear about that?
I think it's unlikely, and I think they're very unlikely to be picked up. I mean, to give a couple of examples, the training program for practitioners in Victoria who want to be eligible to undertake assisted suicide is a purely online course. It's about 6 to 8 hours worth, but of that, only about 5 minutes is devoted to assessing risk factors such as the potential for coercion, lack of volunteer. So the chances of a doctor picking it up are limited. I think there's other evidence that shows that doctors aren't very good at that. There's certainly a very detailed United States study to show that medical practitioners' assessments of the capacity to make decisions is well out of line with results that come from an sort of independent, standardized assessment of capacity. So if they're struggling to assess capacity, I think they're going to be struggling to pick up coercion factors, which can often be incredibly subtle. And if the patient has been coerced to the point where they agree to go along to the doctor, they've probably been coerced to the point where they're going to tell the doctor, yes, it's my decision and I know exactly what I'm doing. How is the doctor realistically supposed to pick it up? Make a further point about that. In Victoria, there's been a huge concentration of the provision of assisted suicide in the hands of a very small number of doctors. I think about 10 doctors are responsible for about 55% of all the assisted suicide approvals in Victoria each year. And what that means is that patients are gravitating, being steered towards those practitioners who have a strong personal commitment to assisted suicide. We saw that from the witnesses to the Public Bill Committee inquiry. And practitioners like that are even less likely to pick up evidence of coercion because they're going to have in their heads the expectation, well, of course this patient will want to die. It's the right and proper thing and sensible thing for them to do. So why should I suspect coercion? So that makes the chances of picking that up even less. But as you know, in fact, there's a very substantial number of people who are potentially at risk of that. Women being victims of domestic violence, older people being at risk of elder abuse, and yet all of that sort of swept under the carpet. It's just yet another example of autonomy for the few and risk and suffering for the many.
Yeah, and I know Victoria doesn't disclose any figures on approvals that have been declined because of domestic abuse or checks for voluntary coercion. Western Australia does disclose how many people have been filtered out by that process, and it's zero. So it's zero. But you would expect like maybe 15% of people would be in a domestically abusive relationship. So there's a huge gap.
Yeah. Well, a further point about filtering out, the last 2 years there have been zero applications for assisted suicide approval that have been rejected. And of course, the proponents will say, well, that shows how wonderfully the system's working. But in fact, what it shows is that they don't actually put the paperwork up for the final sign-off until the public servants have worked with the doctors concerned to get all the paperwork in order. So it's no wonder there's a zero rejection rate. They just shuffle it backwards and forwards until they get it right. So yeah, there's absolutely next to no attention being paid to these risk factors. But I mean, domestic violence figures, I'm sure you both know how serious they are. In Victoria, police attend a domestic violence incident once every 6 minutes out of a population of about just under 7 million. So that's one indication amongst many of the level here. At elder abuse, the estimate is perhaps 1 in 7 people over 60 have experienced elder abuse at some time in their life. So it is a significant risk factor. And just as being a victim of abuse can incline you to suicide generally, as you refer to, it can incline you towards medically assisted suicide as well. But there's no safeguards to pick up on that.
Yeah.
Yeah, I think kind of on a similar parallel. In the U.S., I think it's estimated that 1 in 5 people experience some type of mental illness. 1 in 20 experience serious mental illness. And yet, when you look at how many people are referred for psychiatric evaluations in the assisted dying process, it's fewer than 5 in Oregon. It's 2 or 3 the last few years, which doesn't line up with the population level mental health challenges. One of the reassurances we've heard in the UK is and I gather it may have been inspired by the Victorian model is, we're not going to have the judge anymore, but we're going to bring in this, quote, multidisciplinary panel. There will be a psychiatrist and a social worker and a lawyer, and they will do a really thorough job, a better job than even an independent judge would, of making sure that this person is in the right state of mind and is voluntarily requesting to end their life and is truly terminally ill. I wonder if you could comment on, do you think MPs should feel reassured by the idea of this panel? Or is this, what can they learn from how it's played out in Victoria?
Well, if the Victorian experience is replicated, there's a high risk that this panel will be made up of people who've got a personal commitment to assisted suicide. They agree to be on it because I think assisted suicide's a good thing. That will make them one-eyed and less sensitive to risks than others. It will make them potentially more disdainful of what palliative care can do. And so there's likely to be a skewed assessment, just as there's been skewed oversight here in Victoria. And it won't, of course, it won't provide a safeguard. There's a huge risk that those who are on it are going to have a bias towards assisted suicide that's going to make it hard for them to scrutinise things effectively and dispassionately.
And that's the challenge, isn't it? That you want people with suspicious inquiring minds on these panels who are prepared for assisted dying to actually look bad. The major campaign group in the UK, Dignity in Dying, said that they will collapse their operations and stop campaigning if they win. But what you're saying is that actually your equivalent campaigning organisations, its representatives from there, who are exactly the kind of people who want to go and sit on who want to kind of get involved with the rollout. I mean, they want to be involved. And then you have the Quango responsible has campaigners on it. And so they are doing the campaigning now. They're the ones who are pushing for change.
It's Caesar in judgment on Caesar. There's no dispassionate scrutiny. There's no one with the sort of the auditors, regulatory inspectors frame of mind. I mean, in building or electrical or any other field where there's a high safety risk, you expect the inspector to be there with a suspicion that things could be going wrong and making jolly sure they're not. Certainly in Victoria, the oversight body's there to tick it all off and pat people on the head and tell the public that it's all going swimmingly.
Yeah. I have one more question, and it's a little bit of an unplanned question, so you may not know the answer to it. It's completely fine, but it's just come up as we've been speaking. I'm wondering if you know if there's any monitoring of the economic impact of bringing this legislation into force. I'm wondering particularly, has the Victorian government documented cost savings in terms of healthcare? And then I suppose related to that, has there been reinvestment of those cost savings in palliative care and mental health care? And maybe you don't know the answer. Are you aware? Is there any monitoring? And I guess also really, how much do we know how much it cost? How much it cost to put the whole structure together? And
Well, as far as I'm aware, there's been no such modelling of sort of, as it was, cost benefit payoff. What I've said in the past on that subject is that it's a lot cheaper for governments to introduce assisted suicide than it is to introduce adequate palliative care. And you won't get any MP, minister, public servant saying they're introducing assisted suicide in order to save money. And I'm sure consciously that wouldn't be on their minds. But if you're a cabinet minister in the field of health, it's going to be a lot easier to get through cabinet a proposal to extend assisted suicide than to extend palliative care because it's a lot cheaper. So in Victoria, what we've had is the government set up a statewide delivery service for distributing the lethal substances for assisted dying, and they'll travel the far reaches of the state to get it to if you want to end it all. But they haven't established a similar service to get pain relief medication to people who are in desperate need of pain. And they say, oh, well, you can get that through the normal channels through a pharmacy. But if you've got a loved one dying in pain because the palliative care medicine they've been given doesn't work and it's on a weekend, you've got to find their doctor, you've got to get them to issue a script. You've got to take the script and go around and find a pharmacy that's open, get them to dispense the specialist medicine, and then hope it makes a difference. You've got a patient suffering terribly because of lack of palliative care, and yet the government will rush medication, rush substances to you if you want to die. I mean, the way I sum it up is, if you want to die, you'll get gold standard service. If you want pain relief and care, you'll get bronze standard service. And that's where we've landed in Victoria.
I wanted just to finish off, Robert, by asking you, so you were obviously in Parliament at the time this was rolled out in Victoria. You fought hard to basically get the law not to be passed. I mean, you had fears then about how this would turn out. Have your fears been realised, or have you been somewhat reassured by the actual reality of the last 8 years?
I think, if anything, it's gone worse than I expected. In particular, the vehemence with which practitioners who were opposed to VAD have been victimised has been quite appalling. There are all sorts of assurances respecting freedom of conscience. This would be a system, an option that's available for those that wanted it. Life would go on as usual for everybody else. But in fact, what's happened is the government and the bureaucracy have pushed for the rollout of assisted suicide through every public hospital that might have terminally ill patients, and any practitioner who stands in the way either objects in principle or just objects to the detail of how it's been rolled out in their hospital has been subject to victimisation, professional complaints against them, etc., to the point where a number of them had to change jobs. Some have left the state. Others of them have said to me that whenever they speak publicly, they've got to be very careful to phrase what they say in a way that doesn't seem to be an adverse reflection on assisted suicide. And this persecution, as it were, of practitioners, I think has been quite horrific. And of course, that's not only unfair to the practitioners concerned, it's ultimately bad for patients, because it means that patients who aren't interested in VAD can't find it much harder to go to practitioners who won't be trying to push VAD onto them. It diminishes the pool of expertise, which particularly drives a lot of experienced palliative care practitioners out of the field, because they just feel they can't cope with what they're being expected to do. And it's patients who are going to suffer as a result of that. It's all part of what I touched on earlier, that it's moving the system as a whole away from the first response to suffering being to care and what can we do to help and how can we relieve the suffering, through to, well, if the suffering's too much for you, here's this option available for you of assisted suicide.
Highest few notes. Chelsea and I were so keen that we start to hear some really detailed debate on what assisted dying could look like here in the UK for women. We do not have big money funding, so if you'd like to support us, you can go over to our Substack and subscribe there, or you can donate to The Other Half on our website, theotherhalf.uk/donate. So grateful for this, and so grateful for you listening.